Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular set of videos we are talking about the CSPA, or the Child Status Protection Act, and we've been talking more or less about immediate relative type petitions where the age is locked in under certain circumstances, and when it's locked in it stays there. There's no need to calculate anything else. Pretty much the moment that the U.S. citizen parent becomes a U.S. citizen, or when it was actually filed, the age of the child at the time it was filed, the age is locked in for CSPA purposes. But the question becomes, what if the petitioner is not a USC? What if the petitioner is a lawful permanent resident? Then the CSPA becomes quite a bit more complicated, in that you have to determine how to calculate the age of the child. And by that, under the CSPA, the age is what is looked at, the calculated CSPA age, not the actual age of the person, because the whole purpose is to try to see if you can calculate an age that ends up being under 21, so that the child remains a child for CSPA purposes in order to immigrate. Well, the formula for determining whether a child has aged out for purposes of family, employment, or diversity-based petitions is as follows. And again, remember, this isn't just family-based petitions. You can also use the CSPA on employment-based petitions and diversity petitions, so make sure you keep that in mind. Well, first, you have to determine the age of the child on the date when the immigrant visa became available, or the approval date, whichever is later. Okay, and sometimes that takes some work in order to find out. You have to look at the visa charts, and you have to look at the priority availability, and you go back and you find out when the immigrant visa became available. 2, you need to reduce that number by the days the I-130, the I-140, the I-360, or the I-526, or the diversity visa petition has been pending. And then the child must seek to acquire lawful permanent resident status through either an adjustment or a consular processing within 1 year of the approval of the petition or the availability of the visa, whichever is later, in order to obtain the benefits of the CSPA. So there's a lot of calculation that has to go on in there, but once you determine that, if the date shows that then the child is under 21, you can then process the petition from that point. Okay, more on the coming videos.